Hey guys, welcome back to channel. What you're about to witness is one of those courtroom moments where everything looks routine on the surface, but quickly starts to unravel into something far more chaotic. We're in Colorado, and this case centers around a defendant who repeatedly insists he is not a sovereign citizen. But his arguments, behavior, and legal theories seem to pull straight from that exact playbook. At the same time, the judge and prosecution are trying to keep everything grounded in standard legal procedure.
For Mr. Shadowlands.
Yes, Your Honor.
Come on up, Mr. Shadowlands. And I know that the bondsperson also had mentioned that he wanted to address the court. But anyway, for the record, this is 25T448, 25M352, 25M395, 25M375, 25M318. All people v. Joseph Shadowlands, who appears in person in the courtroom. Mr. McKissick from the District Attorney's Office appears in person as well. You're standing. So Mr. McKissick?
Yes, so I was able to speak with the defendant a little bit about kind of the 5 cases coming up. It doesn't appear that we'd be able to reach a resolution considering some of the things that I would have pointed to as direction for the defendant doesn't seem like something that they would be willing or able to do. This would include picking up one of their issues that they haven't been given any discovery on any of these cases. I let the defendant know that I myself do not give or take in discovery. That's something that can be asked for from the district attorney's office by going there physically and then asking for the discovery, which would be handed over at that time. The defendant let me know that that would not be possible for them, that he was told that if he were to go to the district attorney's office that he would be arrested. It's not typically something that the district attorney's office would impose a arrest for someone coming to pick up discovery without some other maybe factors that haven't been mentioned. So I'm kind of at an impasse as to what to do. It seems like many of the asks by the defendant is not something that I can readily take care of, even though that would be a simple solution, is just going down to the DA's office and getting up discovery. But moreover, he's asked me to take some of his own evidence, which is not something that I was willing to take at this time. I think from a procedural posture in this case, we're once again at an impasse. I think the defendant claims that they're not a sovereign citizen, even though many of their arguments align fully in place with many arguments that I've seen from sovereign citizens. He's asking for a change of venue to a basically a court that we don't have in the state, common law court. So like I explained to them, this precedent that they're brought up is kind of their argument, or perhaps their defense. It's not a valid argument, and there's nothing that I can do as a prosecutor to have the case moved to a court that doesn't exist, essentially.
At this stage, we're already seeing the first major point of friction: discovery. In any criminal case, discovery is a standard process where both sides exchange evidence so the defendant can prepare a defense. But here, the defendant believes something entirely different, that access is being restricted or unfairly controlled. What makes this moment important is how both sides interpret the same process in completely different ways. The prosecution is explaining a standard procedure. Go to the office, request the materials, and obtain discovery through established channels.
On record, she has not read and denied. So I am not aware of any victim. The evidence I was trying to give the state this morning with respect to an alleged victim are rebuttals to affiance. So I do not qualify for an attorney. I cannot afford an attorney due to damages from the state, nor can the state provide a common law a defense with the assumption that I am a domestic terrorist. That is a clear conflict of interest. Your Honor herself has admitted multiple times on record in multiple cases calling me a sovereign citizen, refusing to answer my questions, dismissing them as sovereignty arguments, and so on and so forth. This is clearly due process issues, clearly conflict of interest issues. And I cannot plea or proceed without full discovery of facts, evidence, and elements. There are also issues on the docket today that Miss Hudgens' name is under. I have never consented to an attorney. I have no discovery. I have no complaints. I have not even basic discovery. So how can I defend myself if I can't speedily rebut claims?
Okay, so thank you, Mr. Shadowins. So what I'm hearing is there's an issue about discovery. You know the process to get the discovery, which is to go to their office in Colorado Springs. They have a discovery, apparently some kind of office. And you can obtain all the discovery in these cases. If you hire an attorney, that attorney could also go and request that discovery. And what's the problem with that, sir?
I have receipts. I have emails from DA's office saying, "Do not come here. We will arrest you."
Where are they, sir?
I wasn't prepared to make that argument. I tried to give evidence of rebutting of affidavits today. Prosecution won't take it. Non-response from the DA's office, times 2 prosecutors.
Stop, let's
You-
stop.
allow
I'm
me to
trying
speak, please.
I'm trying
Please
to
do not
get,
rush justice.
can we get
I'm
an
trying to answer your
answer?
question.
Well, I hear that you're saying that you don't have anything
I don't have it
from.
with me today,
Okay.
but I have emails to multiple prosecutors plus Ms. Schaaf, senior investigator, requesting discovery disclosure of evidence. I was told I could go to the police station to pick it up, denying the fact that I have restraining orders from multiple police officers for whistleblowing. Okay, I can't go to pick it up in person because cops took my truck. That was the principal issue leading to all of these cases, a driving versus traveling issue deemed sovereign citizen arguments. I have never been a sovereign citizen. I have common law standing on file with the county, and I cannot get a common law court. So at this point, I don't know how to proceed without evidence. I can't plead without evidence other than non-assumpsit by way of confession and avoidance, and invoke my right to.
Now we start hearing the language that immediately signals this case is going to get more complicated. Terms like common law court, de jure status, and procedural objections begin appearing. From a legal standpoint, these arguments don't align with how criminal courts operate in the United States, but what's important here is not just the content, it's the persistence. The defendant is building a parallel framework of legality, where he believes certain filings, motions, and historical interpretations of law should override or reshape standard court procedure.
You have someone here who perhaps could take you to the district attorney's office in Colorado Springs, although I know because of your past failures to appear, he's had to post bonds, and I think he had some questions about that.
Yes, do I have clearance to not be arrested if I go and try to petition for discovery? I do not wish to motion for discovery with jurisdiction issues raised by the state not affording me the opportunity to rebut. The state twice raised the issue of jurisdiction, and I was not afforded a rebuttal. These affidavits clearly rebutted, and there's no notary present in the court today. Mr. Kissick will not allow me to submit evidence in my defense.
So, the thing also, Mr. Shadowins, is it's very confusing to follow your arguments.
That's because I'm common law and you don't recognize that, which is the bias and conflict of interest.
That is absurd. That is an absurd argument, Mr. Shadowins, and I will not.
Objection, personal opinion.
Thank you.
Fine.
I have made my ruling. It's absurd. So here's what I would, I did, and I will say that I did read the documents that you did file, Mr. Shadowins. Even though your handwriting is not easy for me, I had to, you filed, the last thing that you filed, your motion to dismiss was filed on the day of your last court appearance, and I did not have the time to look at that beforehand.
Motion to reconsider.
Okay. That makes no sense. Haven't ruled. You only asked to reconsider if I've already ruled.
You
I haven't-
dismissed my
Here's,
motion.
I have not,
You
I
dismissed my
told you.
motion to dismiss based saying that you hadn't read it.
The reason that I told you I hadn't read it is because it would take me some time to go through it.
Understood.
So I'm not I did not rule on your motion at the last
Denied
hearing.
it.
In regard to due process of law, I went through your motion for dismissal, Mr. Shadowens, and in regard to due process of law, there's really no clarity about what specifically you're concerned about. But you have, as far as due process rights to be heard and let's see, to understand, well, to be heard and to have really, it says no one shall be condemned without an opportunity to be heard. So you have had the opportunity to be heard. You've appeared in court. There is no violation of due process of law. In regard to the Sixth Amendment, also I will find, as far as due process of law, if your concern is about the statute, the court is, there's nothing specifically about any of the statutes of which you're alleged to have violated, you've not said, oh, they're not sufficiently clear to persons of ordinary intelligence to afford a practical guide for law-abiding behavior and capable of even-handed enforcement. All the statutes in these cases that have been charged as violations against you, court does find that they are sufficiently clear to persons of ordinary intelligence and they are capable of even-handed enforcement.
I don't even
In
know what that
regard,
means, Your Honor.
wait,
I'm
I'm responding to you raise these issues. You write due process of law with no real explanation. I have to make assumptions about what that means.
Objection, the court would not hear it.
In Sixth Amendment,
Dismissing it as sovereignty arguments, end
I
quote.
have not dismissed. I am ruling right now,
You
Mr.
can't rule, you haven't heard the matter.
Mr. Shadowens, I did read your motion and I am ruling right now, so be quiet. In regard to the Sixth Amendment, that the Sixth Amendment provides for speedy public trial by an impartial jury, you be informed of the nature and cause of your accusations, that you are confronted by witnesses against you, have a right to subpoena witnesses and right to counsel. You have all of those rights. None have been denied to you. In regard to obstruction of justice, there's no, the court denies that or dismisses that argument. There's no specifics. It just simply says obstruction of justice. Prosecutors refusing to respond with discovery, court denies that. Court notes that the district attorney has provided information how Mr. Shadowens.
This moment introduces a rare but noticeable shift in tone. After sustained legal back and forth, the courtroom briefly dips into sarcasm and humor. While courts are typically formal environments, moments like this sometimes emerge when frustration builds after repeated circular arguments. The comment itself is clearly not part of the formal ruling process. It reflects the growing strain in communication between procedural law and non-traditional legal arguments being presented. What makes it stand out is how it highlights the gap between the court's expectations and the defendant's continued reliance on unconventional legal theories.
I did, it's on file.
All right, I have ruled that, that nothing about the state, the fact that all your cases are the state of Colorado versus you does not prevent those cases from proceeding forward. Those cases will continue. In regard to change of venue, there's no reason under Rule 21A of the Colorado Rules of Criminal Procedure to find that you would not be able to obtain a fair or expeditious trial in Teller County. So I deny that request at this time. If you wish to submit some additional information about why you think there should be a change of venue under Rule 21, you should follow the rules there.
I do, it's
No,
right here. I'd like to
irrevocable-
read it for the record, please.
Irrevocable trust is an absurd argument. Traveling, not driving. I did rule on the record in this, on that issue before. In People v. Zen, the right to drive a car on public roads is not a fundamental right. States do have the right to regulate the use of motor vehicles on roads in this
Prove
state.
up the claim of a
so that-
contract of a
so
valid
that-
driver's license.
So that argument regarding traveling, not driving is denied. Impossibility to obtain your driver's license. I have no authority over the Department of Motor Vehicles. That's something you will have to deal with the Department of Motor Vehicles about. You have been in this courtroom all morning and heard different people talk about their efforts to obtain their driver's license. You can certainly get that information from the Department of Motor Vehicles. In regard to WebEx authorization, you are authorized to appear by WebEx, and you have appeared by WebEx on the last court date. Again, you raise the same issue regarding discovery. I have already advised you that how you get that discovery. All I can do is say, well, if the clerks did not get message regarding your request to appear by WebEx, and that's why you had a failure to appear, we do the best we can. We're not perfect, but we do try and get information to you as quickly as possible. Again, you have no injured party, the victim listed as the state of Colorado. Again, that is not the state of Colorado. Represented by the district attorney's office is representing the rights of the public
And the judge and the jailer and the.
to enforce the laws. No, anyway, I rule, you can interrupt and try and prevent me from saying things.
You're not reading the
Shadow.
complete record, ma'am.
I am reading it and.
I object.
I understand you object, and that's
I heard
fine.
my objection.
No, as far as a valid warrant, you actually did.
Here, we see a major escalation in the defendant's framing of the case. The argument is no longer just about discovery or procedure. It expands into claims of conflict of interest, constitutional violations, and systemic bias. Legally speaking, allegations of bias or conflict must typically be supported with specific evidence, not general assertions. But what's important in this moment is how the defendant is attempting to reframe procedural disagreements into constitutional-level grievances. This is a common escalation pattern in high-tension self-representation cases. Procedural dissatisfaction transforms into broader claims about fairness, authority, and legitimacy of the court itself.
It's called the Arguello Advisement. It's based on a case 772 P. 2nd 87. I have to ask these questions of you since we are setting all your cases for trial and you have no attorney. Do you understand that anything you say can be used against you?
Yes.
Do you understand you have the right to be represented by an attorney throughout these proceedings?
Yes.
Do you understand that if you cannot afford an attorney, one will be provided for you free of charge? You have to apply for the public defender and see if you're
I don't
eligible.
qualify.
Okay, all right. Do you understand I will appoint counsel if you want an attorney to represent you? Of course, you must be eligible financially for their assistance.
I'm not due to injury from the state.
All right. Do you understand the charges against you are
No.
multiple, Mr. Shadowens? You have failure to display proof in 25T448. There's failure to display proof of insurance, which is a class 1 traffic misdemeanor carrying possible penalties of 10 days to 1
Due to
year.
disability,
10 days to 1 year. in the
impossibility.
and or $500 to $1,000 fine. You're charged with driving under restraint, a Class A traffic infraction carrying a fine. You're also charged with having a fictitious registration plate, which carries 10 to 90 days in the county jail and or $150 to $300.
I have a rebuttal.
You also have a registration unregistered vehicle, which I believe is a class be, give me a second, traffic infraction, I believe. 5448.
I have a rebuttal, Your Honor.
No.
I'd like to read a record on for the record, which reads, and I quote,
I am doing the Arguello advisement, Mr. Shadowins, which means I have to go through all your
I don't
charges.
have an attorney.
in 5
I don't have an
cases.
attorney. I
I
can't
know,
defend
and
myself
that's-
on 5 cases with no evidence.
That's
I
what-
would just like to read a record.
No.
And get an
Not-
attorney.
Not.
Can we set the matter over when I speak to counsel, please? I have disabilities.
Are
I'm
you going
really
to
overwhelmed.
to hire counsel, Mr.
I can't
Shadowins?
hire counsel. The court said they would appoint attorney. I don't apply. I don't qualify for a public defender.
I'm gonna-
Even though the public defender is named on some of these cases, I've never spoken to, Your Honor.
We'll take them off. We'll make sure her name is off of that. But I am right now in the midst of the Arguello advisement. We're going to set your cases for trial. You're entering not guilties. We're setting your case for trial and pretrial readiness. To do that, I have to run through these questions with you.
Thank you for the
in
point of
order
fairness.
to-
Can I take a moment to recess, please?
Why?
Because I have service-connected disabilities to include PTSD and schizophrenia, and I'm extremely overwhelmed due to the nature of the adversarial nature of this proceeding.
Okay, go ahead, sir.
When would you like me back?
You 5 minutes. I'll give you 5 minutes.
To address,
5 minutes.
to address bond.
I posted a bond for
What's your name?
John Maynard.
Yeah. Hello, Mr. Maynard.
Good morning.
And what is your, what's your concern right now? I'm just
My
trying.
question was,
Asking.
what are the criteria that will release the bond that I posted for Mr. Shadowins?
Uh,
Was his appearance today adequate to release it?
no, generally what the bond paperwork, and let me just pull up. Looks like, for example, you've posted the bond in 20.
At this point, the defendant begins introducing claims of documented evidence, emails, communications, and attempts to obtain discovery. This is where things become more complicated procedurally, because now there's an assertion of proof being available, but not formally entered into the record during the hearing. The court has to operate within strict rules about how evidence is submitted. Simply referencing documents or claims is not enough. They must be properly presented, verified, and entered through appropriate legal channels. What we are seeing here is a disconnect between intention and procedure.
Shadowins, he's back in the courtroom.
Apologies, Your Honor. I just needed a drink of water and a breath. Thank
That's-
you.
That's fine. All right, and then the last charge there is a Class B traffic infraction, which it carries a fine only. The next case is 25M352, in which you're charged with harassment, insults, taunts, 352.
Against who?
So that is against Chantel Natalie Chantel.
Entire complaint is hearsay.
Uh-huh. Well, you would be,
I'll
we're
deal with
setting
that
the
at trial.
case for trial, exactly, and you can confront any witnesses against you, certainly. But so in that case, you're facing potential penalties of, let's see, a Class 2 misdemeanor carries possible penalties of up to 120 days in the county jail and/or up to a $750 fine. You've also got disorderly conduct and trespass in the 3rd degree, both petty offenses, carrying possible penalties of up to 10 days in the county jail and a $300 fine. Then we have 25M395, in which you're alleged to have resisted arrest, a Class 2 misdemeanor, up to 120 days in the county jail and/or up to a $750 fine. In 25M375, you're alleged to have 375. In that case, you're alleged to have provided false reporting of identification information to police, also a Class 2 misdemeanor, up to 120 days in the county jail and/or up to a $750.
What named identification?
The affidavit for arrest warrant indicates that you gave false reporting information to Officer Lupia. you said you called 911 to report you were being gang stalked by law enforcement. Call screen, as he would not be held responsible if he were to defend himself. Call screen. Joseph told dispatcher that law enforcement had kidnapped him and stolen his vehicle. Joseph is referring to regarding being kidnapped and having his vehicle stolen was when WPPD conducted a traffic stop while he was driving the vehicle. Probable cause was established for multiple violations and the vehicle was towed. He got a voluntary, so it's false reporting to law enforcement. That's what
Thank you.
they're saying. All right. And then we have 25M318, which is, excuse me,
Bless you.
25M318. Sorry, I'm just trying to get to what that next one is. That in that case, the charges are harassment, strike, shove, kick, which is a class 1 misdemeanor carrying possible penalties of up to 364 days in the county jail and or up to $1,000 fine. You're also charged with false reporting, fake crime, which is a class 2 misdemeanor carrying possible penalties of up to 120 days in the county jail and up to a $750 fine. So, Mr. Shadowins, you are facing some pretty substantial possible penalties. Do you understand? I know you disagree with the charges, but do you understand the charges and the possible penalties?
No, and I reject all charges.
Okay. Do you have any legal training? Do you have any legal training, Mr. Shadowins?
Not in statutory law. I am only learned in common law, which this court does not recognize, nor Article 3 of the Constitution by your own omission. So I cannot get a fair trial in this court.
Gotcha. How far have you gotten in school?
This is where the hearing becomes openly confrontational in tone. The judge begins explicitly identifying the pattern of arguments as aligning with sovereign citizen ideology, even while the defendant denies that label. What's important here is the court's perspective. Judges don't classify individuals based on labels, but based on the substance of arguments being made. When certain legal theories repeatedly appear, such as jurisdiction challenges, common law courts, or refusal of standard legal procedure, they are recognized patterns. The defendant, however, rejects that classification and attributes it to bias or misinterpretation.
What is your desire with respect to appointment of advisory counsel to assist you in preparing your defense? No response. Okay. So bless you, given that Mr. Shadowins seems to feel or is indicating that he has mental health problems, I'm going to
Objection assumptive.
I'm going to issue a mental health stay, and I'm going to order competency evaluations in the cases here. So it will be a condition of the bond, Mr. Maynard, so this is going to be a condition of his bond as well, that he cooperate and do the evaluation by the psychiatrist. I am going to do an additional advisement to you, given that I'm going to order a competency evaluation. At this time, the court has determined it has insufficient evidence to make a preliminary finding regarding your competency to proceed. The court is going to order that you undergo an evaluation regarding your competency to proceed. The court will now advise you of the nature and consequence of the proceeding and of your rights under 16-8.5-109. Before you talk with anyone, you have the right to have an attorney appointed and to confer with your attorney. You will undergo an examination concerning your competency to proceed. You will be examined by one or more psychiatrists or psychologists. You have the right not to say anything to the psychiatrist or psychologist. You shall cooperate with the competency evaluator and with other personnel providing services. Statements you make during the evaluation shall be protected as provided in 16-8.5-108. Statements you make during the examination cannot be used against you during the prosecution's case in chief, but can be used as rebuttal or impeachment or during sentencing. If you choose not to cooperate with the competency evaluator and other personnel, and the lack of cooperation is not the result of a developmental disability or a mental disability, the fact of your non-cooperation may be admissible in your competency or restoration hearing to rebut any evidence you in competency evaluation. An evaluator may render an opinion of your competency based upon confessions, admissions, and any other evidence of the circumstances surrounding the commission of the offenses, as well as your known medical and social history. The opinion may be admissible into evidence at your competency or restoration hearing. By raising the question of competency, any claim of confidentiality or privileged is deemed waived, and all parties will have access to competency evaluation reports, information, and documents relating to the competency evaluation that are created by, obtained by, reviewed by, or relied on by the evaluator. A written report of the evaluation will be prepared and provided to defense counsel. Well, if you have an attorney, to your defense counsel. It will be provided to the district attorney and to the court. Within 7 days after receipt of the report, either party may request a hearing or a second evaluation. If you are found incompetent, you will be ordered to undergo competency restoration. This can take place on an outpatient or an inpatient basis. During that time, you are entitled to a hearing as to whether your competence has been restored. At a competency hearing, you and the prosecuting attorney are entitled to be present in person to examine any reports of the evaluation or other matter to be considered by the court as bearing upon the determination, to introduce evidence, summon witnesses, cross-examine opposing witnesses or witnesses called by the court, and to make opening and closing statements and arguments. The court may examine or cross-examine any witness called by you or the prosecuting attorney and may summon and examine witnesses on its own motion. Once your competence is restored, we will resume these criminal proceedings from the point that we are at now. All right.
Let the record show Your Honor proceeded with an objection she didn't answer to. The court didn't respond to my objection. Are you assuming that I am incompetent? You said I'm being restored to competency.
I don't have enough information to
Okay, thank you
determine
for
whether
clarity, but you had an objection and proceeded without. So I'm challenging jurisdiction in all matters, and I rest, and I'm not the defendant here. I do not accept the charges.
Well,
The state
sir,
is ordered to prove up the claim of a contract in any of these matters.
of course, the people have the burden to prove all charges.
Well, how can they?
Elements
You're
of
making
each
an
charge.
entire case for them, colluding with the same.
When the
Clear conflict of interest.
the people have the burden to prove beyond a reasonable doubt each element,
So
all
they have-
elements of each charge beyond a reasonable doubt.
Can't-
Right now, we're on a stay, sir, because we're not proceeding any further in the cases.
When's my evaluation?
Um,
Your jurisdiction is challenged and cannot proceed absent proof of jurisdiction.
Article 6 of the Colorado Constitution, Sections 1 and 16, and CRS 13-6106. I have subject matter jurisdiction under Article 6 of the Colorado Constitution, Section 17, CRS 18-1-201.
Are you colluding with the prosecution?
13.
It's,
No, sir.
are you claiming that that's evidence
These are,
for the prosecution? The state is making the state's position?
sir,
I just want my competency hearing date, and I want to get out of here. This is clearly a witch hunt.
I am
I'm
telling
done.
you, I am responding to
No,
your
no, you're
argument.
not. You're
One-
litigating for the prosecution.
I am
who
not.
does not have jurisdiction.
I am not. I have to find that I have jurisdiction, and I do.
Objection.
So stop, sir. I'm going through the statutes to tell you, Section 17 of Article 6 of the Colorado Constitution and CRS, these are
Prove up the
statutes, sir.
claim that I signed that and
18-1.
agreed to any of that.
18-1-201 and 13-6-106. I have personal jurisdiction as the
At this point, the judge delivers a structured and detailed breakdown of due process, discovery, and constitutional rights, reinforcing that the defendant has been given procedural opportunities to be heard and respond within the court system. Despite repeated objections, the court maintains that the required legal standards, notice, hearing, representation rights, and access to procedure, have been upheld. What stands out in this entire hearing is not just the disagreement, but the repeated collision between personal legal interpretations and formal judicial procedure. The court is operating strictly within statutory law, while the D.